Question 1. Analysis of a real estate agent's marketing strategy for a residential property in Perth, Western Australia, reveals a plan to utilize print advertising, host an open house, and engage in professional networking. Considering the regulatory framework in Western Australia, which of the following approaches best balances effective marketing with ethical and legal obligations? Option A. Utilize print advertising that includes speculative future value projections based on market trends, and network by sharing seller motivation and financial details with other agents to expedite a sale. Option B. Develop a comprehensive print advertisement detailing the property's features, price range, and agent contact information. Conduct a well-organized open house with licensed agents present to answer inquiries accurately, and leverage professional networks to inform other agents about the listing. Option C. Focus exclusively on a print advertisement with minimal property details, assuming potential buyers will inquire for more information, and avoid open houses to minimize agent time investment. Option D. Create a print advertisement that highlights only the most attractive aspects of the property, using vague language to suggest potential without disclosing specific limitations, and rely on informal gatherings at the property to attract buyers. Correct answer is B. Develop a comprehensive print advertisement detailing the property's features, price range, and agent contact information. Conduct a well-organized open house with licensed agents present to answer inquiries accurately, and leverage professional networks to inform other agents about the listing. Explanation. Scenario analysis. This scenario presents a common challenge for real estate agents in Western Australia, effectively marketing a property while adhering to the strict ethical and regulatory requirements governing advertising and client representation. The challenge lies in balancing the need to attract potential buyers with the obligation to provide accurate, non-misleading information and to act in the best interests of the seller. Missteps in traditional marketing can lead to breaches of the Real Estate and Business Agents Act 2002, WA, and its associated regulations, as well as damage to professional reputation. Correct approach analysis. The most effective and compliant approach involves a multifaceted traditional marketing strategy that prioritizes transparency and accurate representation. This includes a well-crafted print advertisement that clearly states the property's key features, price, if disclosed, and agent contact details, ensuring it complies with advertising guidelines that prohibit misleading statements or omissions. Complementing this, a well-organized open house event, managed by a licensed agent who can answer questions truthfully and professionally, provides direct engagement. Finally, leveraging established professional networks, such as informing other agents within the local market about the listing, can generate qualified leads. This integrated approach maximizes exposure while maintaining ethical standards and regulatory compliance by ensuring all representations are factual and that the agent acts with due diligence. Incorrect approaches analysis. One incorrect approach involves relying solely on a print advertisement that omits crucial details about the property's condition, such as known structural issues or significant repair requirements, and uses vague language to inflate perceived value. This is a direct contravention of the duty to provide accurate information and can be considered misleading advertising under WA regulations, potentially leading to disciplinary action. Another flawed strategy is to conduct an open house without adequate preparation or supervision, allowing unqualified individuals to make unsubstantiated claims about the property or its potential, which can create liability for the agent and seller. Furthermore, a networking approach that involves sharing confidential seller information with other agents without explicit consent, or engaging in practices that could be construed as collusion or price fixing, would violate ethical duties of confidentiality and fair dealing. Professional reasoning. Professionals should approach property marketing by first understanding the seller's objectives and the property's true characteristics. A thorough property inspection and disclosure of all material facts are paramount. Marketing materials, including print advertisements, must be factually accurate and avoid hyperbole. Open houses should be professionally managed, with agents prepared to answer questions honestly and guide potential buyers appropriately. Networking should be conducted ethically, respecting client confidentiality and fair competition principles. The decision-making process should always prioritize compliance with the Real Estate and Business Agents Act 2002, WA, and its regulations, alongside the agent's fiduciary duties to the seller. Question 2. The review process indicates that a proposed residential subdivision in Western Australia, adjacent to a sensitive wetland ecosystem, has had its initial environmental impact assessment flagged by the Environmental Protection Authority due to concerns about the adequacy of its stormwater management plan in protecting water quality and biodiversity. Which of the following actions represents the most responsible and legally compliant approach for the developer? Option A. Argue to the Environmental Protection Authority that their concerns are overly precautionary and that the current stormwater management plan is sufficient without providing additional scientific justification. Option B. Focus solely on meeting the minimum legal requirements for stormwater management as outlined in the Environmental Protection Act 1986, WA, without exploring advanced mitigation strategies or best practice recommendations. Option C. Undertake further detailed environmental studies to accurately assess potential impacts and develop a comprehensive, implementable stormwater management plan, incorporating best practice mitigation techniques, and proactively engage with the Environmental Protection Authority to address their concerns. Option D. Submit a revised environmental impact assessment report with minor textual adjustments to the stormwater management section, asserting that the existing plan meets all regulatory requirements. The correct answer is C. Undertake further detailed environmental studies to accurately assess potential impacts and develop a comprehensive, implementable stormwater management plan, incorporating best practice mitigation techniques, and proactively engage with the Environmental Protection Authority to address their concerns. Explanation. The review process indicates that a property developer is proposing a new residential subdivision in the Perth metropolitan area of Western Australia. The proposed site is adjacent to a significant wetland system that is known to support a variety of native flora and fauna, including some species listed as vulnerable under Western Australian legislation. The developer's Initial Environmental Impact Assessment (IA) report, submitted to the Western Australian Environmental Protection Authority (EPA), has been flagged for potential deficiencies regarding the long-term management of stormwater runoff and its potential to impact the water quality of the adjacent wetland. This scenario is professionally challenging because it requires balancing development interests with the imperative to protect sensitive environmental assets, as mandated by Western Australian environmental law. The developer's obligation extends beyond mere compliance to ensuring sustainable development practices that mitigate potential harm. The best professional approach involves proactively engaging with the EPA and relevant environmental consultants to address the identified deficiencies in the EIA. This means undertaking further detailed studies to accurately assess the potential impacts of stormwater runoff on the wetland's water quality and biodiversity. Crucially, it requires developing a robust and implementable stormwater management plan that incorporates best practice techniques such as permeable paving, bioswales, and retention basins, designed to minimize pollutants and manage flow rates. This approach is correct because it directly addresses the EPA's concerns, demonstrates a commitment to environmental stewardship, and aligns with the principles of the Environmental Protection Act 1986, WA, and the EPA's policies on stormwater management and biodiversity conservation. It prioritizes a thorough, evidence-based response to regulatory scrutiny, an approach that involves simply submitting a revised EIA with minor textual amendments without undertaking further substantive studies or implementing significant changes to the proposed stormwater management system would be professionally unacceptable. This fails to address the core concerns raised by the EPA regarding the adequacy of the assessment and the proposed mitigation measures. It risks regulatory rejection and potential legal challenges, and it breaches the ethical duty to ensure development does not cause undue environmental harm, as stipulated by the Environmental Protection Act 1986, WA. Another professionally unacceptable approach would be to argue that the existing stormwater management plan is sufficient and that the EPA's concerns are overly precautionary, without providing robust scientific evidence to support this claim. This dismissive stance ignores the statutory responsibilities under the Environmental Protection Act 1986, WA, to adequately assess and mitigate environmental impacts, particularly concerning protected flora and fauna. It demonstrates a lack of due diligence and a failure to engage constructively with the regulatory process. Finally, an approach that focuses solely on meeting the minimum legal requirements without considering best practice or the long-term ecological health of the wetland would also be flawed. While legal compliance is essential, professional responsibility in environmental matters often extends to adopting higher standards to ensure genuine sustainability and minimize residual impacts. This approach risks creating future environmental problems and reputational damage, even if technically compliant at the time of approval. Professionals should adopt a decision-making framework that prioritizes thorough environmental assessment, proactive engagement with regulatory bodies, the development of evidence-based mitigation strategies, and a commitment to best practice principles that go beyond minimum legal compliance. This involves understanding the specific legislative requirements of Western Australia, such as the Environmental Protection Act 1986, WA, and applying them diligently to protect environmental values. Question 3. Performance analysis shows a client in Western Australia is inquiring about purchasing their first home and has specifically asked about the availability and benefits of FHA, VA, and USDA loans, believing these programs are accessible for first home buyers in Australia. As a licensed real estate agent in Western Australia, how should you best address this client's inquiry? Option A. Explain that FHA, VA, and USDA loans are indeed available in Western Australia, but they have specific eligibility criteria that you can help them understand and meet. Option B. Advise the client to research general government grants for home buyers and assure them that you will assist in navigating any applicable programs once they identify them. Option C. Inform the client that while direct FHA, VA, and USDA loans are not applicable, you can help them find lenders who offer similar government-backed loan products that you can facilitate. Option D. Explain that FHA, VA, and USDA loans are not available in Western Australia, and instead guide them towards understanding the Keystart Home Loan Scheme and other relevant Western Australian government initiatives for first home buyers, advising them to consult directly with Keystart or a mortgage broker for eligibility. The correct answer is D. Explain that FHA, VA, and USDA loans are not available in Western Australia, and instead guide them towards understanding the Keystart Home Loan Scheme and other relevant Western Australian government initiatives for first home buyers, advising them to consult directly with Keystart or a mortgage broker for eligibility. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a real estate agent in Western Australia to navigate the complexities of government-backed loan schemes, which are not as prevalent or structured in the same way as in the United States. The agent must understand the limitations and specific requirements of any Western Australian government initiatives that might assist first home buyers or those with specific needs, while also being aware that direct equivalents to FHA, VA, or USDA loans do not exist in WA. Misrepresenting available government assistance or failing to accurately inform clients about the true nature of financial support can lead to significant client dissatisfaction, potential financial repercussions for the client, and damage to the agent's professional reputation and licensing. Correct approach analysis. The best professional approach involves accurately informing the client that Western Australia does not have direct equivalents to the FHA, VA, or USDA loan programs common in the United States. Instead, the agent should guide the client towards understanding the Western Australian government's existing schemes designed to assist home ownership, such as the Keystart Home Loan Scheme. This approach involves explaining the eligibility criteria, benefits, and limitations of Keystart, and advising the client to consult directly with Keystart or a qualified mortgage broker to determine their specific eligibility and the best financial pathway. This is correct because it is truthful, adheres to the regulatory landscape of Western Australia, and empowers the client with accurate information to make informed decisions, thereby fulfilling the agent's duty of care and disclosure obligations under Western Australian real estate regulations. Incorrect approach is analysis. Misleading the client by suggesting that FHA, VA, or USDA loans are available in Western Australia is a significant regulatory and ethical failure. These programs are specific to the United States federal government and have no applicability or legal standing in Australia. This misrepresentation breaches the agent's duty to provide accurate information and could lead the client to pursue a non-existent financial avenue, causing wasted time, effort, and potential financial loss. Suggesting that the agent can facilitate or guarantee access to a government-backed loan without specifying a legitimate Western Australian scheme is also professionally unacceptable. This implies a level of influence or knowledge of a non-existent program, which is misleading. It fails to acknowledge the actual process of obtaining government assistance in WA, which typically involves direct application to specific state bodies or approved lenders, and bypasses the necessary due diligence required for such financial arrangements. Recommending that the client simply look for government grants, without providing specific, actionable information about Western Australian schemes like Keystart, is insufficient. While grants may exist, a professional agent should be able to direct clients to the relevant programs and explain their general purpose. This vague advice fails to meet the standard of care expected of a real estate professional who should be knowledgeable about the local market and available assistance programs. Professional reasoning. Professionals should adopt a framework of accurate disclosure and client education. This involves first understanding the specific regulatory environment of the jurisdiction they operate in, Western Australia. When a client inquires about a concept prevalent in another jurisdiction, like U.S. government-backed loans, the professional's first step is to clarify that such programs do not exist locally. Subsequently, the professional must proactively identify and explain any analogous or relevant local government initiatives, like Keystart. The decision-making process should prioritize client understanding and informed consent, ensuring all advice is grounded in the actual laws and available programs of Western Australia, and directing clients to appropriate financial institutions or government bodies for definitive advice. Question 4. Quality control measures reveal that a real estate agent in Western Australia is representing a seller who is aware of a significant structural defect in the property that has not been disclosed to the prospective buyer. The agent is considering how to proceed with the sale. Which of the following approaches best navigates the legal and ethical considerations for contract enforceability in Western Australia? Option A. Advise the seller to disclose the structural defect to the prospective buyer before the contract is finalized. Option B. Suggest the seller undertake cosmetic repairs to conceal the structural issue before the buyer's inspection. Option C. Advise the seller to proceed with the sale without mentioning the defect, hoping the buyer does not discover it. Option D. Advise the seller to wait for the buyer to raise concerns about the property's condition before mentioning the defect. The correct answer is A. Advise the seller to disclose the structural defect to the prospective buyer before the contract is finalized. Explanation. This scenario presents a professional challenge due to the potential for a contract to be deemed voidable, impacting the rights and obligations of both the buyer and seller. The agent's duty of disclosure and the enforceability of the contract hinge on adherence to Western Australian WA property law principles. Careful judgment is required to ensure the agent acts ethically and legally, protecting their client and avoiding potential litigation. The best professional approach involves immediately advising the seller to disclose the known structural defect to the prospective buyer. This aligns with the principles of good faith and honesty fundamental to contract law and the agent's fiduciary duties. Under the Sale of Land Act 1970 WA, while not explicitly mandating disclosure of all defects, the overarching principles of contract formation require that parties enter into agreements with full knowledge of material facts that could influence their decision. Failure to disclose a significant structural defect could render the contract voidable at the buyer's option due to misrepresentation or non-disclosure of material fact. By encouraging disclosure, the agent facilitates an informed decision by the buyer, strengthening the enforceability of the contract and upholding ethical standards. An incorrect approach would be to advise the seller to proceed with the sale without disclosing the defect, hoping the buyer does not discover it. This is professionally unacceptable as it constitutes deceptive conduct and a breach of the agent's duty of care and good faith. It exposes the seller to significant legal risk, including the buyer rescinding the contract and seeking damages. Ethically, it violates the principle of transparency and fair dealing. Another incorrect approach would be to suggest the seller undertake minor cosmetic repairs to mask the structural issue before the buyer's inspection. This is also professionally unacceptable because it is a form of active concealment, which is even more egregious than passive non-disclosure. It directly misleads the buyer about the property's condition and is a clear breach of ethical obligations and potentially fraudulent. Finally, Advising the seller to wait for the buyer to raise concerns about the property's condition before mentioning the defect is also professionally unacceptable. This passive approach still fails to meet the standard of proactive disclosure expected of a real estate professional. It relies on the buyer's diligence to uncover a known issue, rather than fulfilling the agent's responsibility to ensure a fair and transparent transaction. Professionals should adopt a decision-making framework that prioritizes transparency, honesty, and compliance with WA property law. This involves understanding the material facts of a property, assessing their potential impact on a buyer's decision, and advising the seller on the legal and ethical implications of disclosure. When a known defect exists, the default professional action should be to advocate for full and honest disclosure to ensure contract enforceability and maintain professional integrity. Question 5. Investigation of a property in the Swan Valley region of Western Australia reveals it has historically been used for viticulture and winemaking, with substantial agricultural infrastructure. However, the current owner has recently obtained preliminary council approval for a boutique tourism venture that includes limited residential accommodation, and the property is situated in a zone that permits both agricultural and certain tourism-related activities. What is the most appropriate classification and marketing approach for this property under Western Australian real estate regulations? Option A. Classify and market the property as a residential property with potential for agricultural use, focusing on the approved accommodation and overlooking the primary agricultural zoning. Option B. Classify and market the property solely as a commercial tourism development, emphasizing the residential accommodation aspect and downplaying its agricultural history. Option C. Classify and market the property exclusively as an agricultural property, focusing on its viticulture and winemaking capabilities, and ignoring the approved tourism development. Option D. Classify and market the property primarily as a mixed-use property, highlighting its agricultural heritage and the approved tourism development potential, while ensuring full disclosure of all zoning regulations and the specifics of the council approval. Correct answer is D. Classify and market the property primarily as a mixed-use property, highlighting its agricultural heritage and the approved tourism development potential, while ensuring full disclosure of all zoning regulations and the specifics of the council approval. Explanation. This scenario presents a professional challenge due to the inherent complexities in classifying real estate, particularly when a property exhibits characteristics of multiple types. Misclassification can lead to significant legal, financial, and ethical repercussions for the agent, their client, and potentially the buyer or tenant. In Western Australia, the Property Occupations Act 2014 WA and associated regulations govern the conduct of real estate agents, emphasizing honesty, transparency, and acting in the best interests of clients. The challenge lies in accurately identifying the primary use and legal classification of a property to ensure compliance and prevent misrepresentation. The correct approach involves a thorough investigation of the property's current use, zoning regulations, and any relevant encumbrances or covenants that define its legal status. This includes consulting official town planning schemes and local government records to ascertain the property's permitted uses. For a property that has been historically used for agricultural purposes, but is now being marketed with significant residential development potential, the agent must determine its primary legal classification according to WA planning laws. If the land is zoned for agricultural use but has received approvals or is in the process of being rezoned for residential development, the agent must disclose this information accurately. The best professional practice is to classify the property based on its current legal zoning and permitted uses, while also transparently disclosing any potential for future development or alternative uses that have been officially sanctioned or are under active consideration by the relevant authorities. This ensures that potential buyers or lessees are fully informed about the property's status and future possibilities, aligning with the agent's duty of care and disclosure obligations under WA law. An incorrect approach would be to solely market the property based on its most lucrative potential use, e.g., residential development, without confirming its current legal zoning and permitted uses. This misrepresents the property's current status and could lead to a buyer purchasing land that cannot be used as intended, violating the agent's duty to provide accurate information. Another incorrect approach is to ignore the historical agricultural use and associated land management agreements or restrictions, which may still be legally binding and impact future development or use, even if residential structures are present. Furthermore, failing to disclose any ongoing rezoning applications or the possibility of future rezoning, even if not yet approved, is a failure of transparency and can mislead prospective parties. Professional decision-making in such situations requires a systematic process. First, understand the client's objectives for selling or leasing. Second, conduct comprehensive due diligence on the property, including verifying its legal classification through official channels like the WA Landgate and local government planning departments. Third, identify all potential uses and any restrictions or conditions associated with them. Fourth, communicate all findings clearly and accurately to the client and prospective parties, ensuring all disclosures are documented. Finally, classify the property according to its primary legal zoning and permitted uses, while providing full disclosure of any other relevant characteristics or potential uses. Question 6. Comparative studies suggest that the implementation of real estate investment trusts, REIT, as an investment vehicle in Western Australia can offer diversification benefits. An investment advisor is considering recommending a particular REIT to a client. What is the most prudent and compliant approach for the advisor to take in Western Australia? Option A. Recommend a REIT that has demonstrated strong historical returns over the past 5 years, as this indicates a reliable investment opportunity for the client. Option B. Conduct a thorough assessment of the client's financial situation, risk tolerance, and investment goals, and then research and recommend a REIT that is properly registered, compliant with Australian Securities and Investments Commission, ASIC regulations, and for which full disclosure of risks, fees, and potential conflicts of interest is provided to the client. Option C. Suggest the client invest in a newly established REIT that promises high yields, prioritizing potential capital growth over detailed risk assessment and regulatory checks. Option D. Advise the client to invest in a REIT that is marketed as having significant tax advantages, without thoroughly investigating the underlying assets or the REIT compliance with Western Australian property laws. The correct answer is B. Conduct a thorough assessment of the client's financial situation, risk tolerance, and investment goals, and then research and recommend a REIT that is properly registered, compliant with Australian Securities and Investments Commission, ASIC regulations, and for which full disclosure of risks, fees, and potential conflicts of interest is provided to the client. Explanation. This scenario presents a professional challenge because it requires an investment advisor to navigate the complexities of real estate investment trusts, REIT, within the specific regulatory landscape of Western Australia, balancing client interests with legal obligations. The advisor must understand how REIT are structured and regulated in WA, particularly concerning disclosure requirements, and the potential for conflicts of interest when recommending them. Careful judgment is required to ensure that any recommendation is suitable for the client's financial situation and risk tolerance, and that all relevant WA legislation and professional conduct standards are met. The best professional approach involves a thorough due diligence process that prioritizes client suitability and regulatory compliance. This includes a comprehensive assessment of the client's financial objectives, risk profile, and investment horizon. The advisor must then research and select REIT that are registered and compliant with Australian Securities and Investments Commission, ASIC, regulations, and relevant WA property laws. Crucially, the advisor must provide clear, transparent, and accurate disclosure to the client regarding the nature of the REIT investment, its associated risks, fees, and any potential conflicts of interest. This approach aligns with the principles of responsible investment advice, emphasizing client best interests and adherence to the Corporations Act 2001, CTH, and any specific WA property investment guidelines. Recommending a REIT solely based on its historical performance without a detailed client suitability assessment is professionally unacceptable. This fails to consider the client's individual circumstances, potentially leading to an unsuitable investment and a breach of the advisor's duty of care. Furthermore, failing to disclose all relevant risks and fees associated with the REIT, or any potential conflicts of interest the advisor may have, constitutes a breach of disclosure obligations under Australian consumer law and financial services regulations. Promoting a REIT without verifying its compliance with WA property development and strata title regulations, if applicable, could also expose the client to legal and financial risks. Professionals should adopt a structured decision-making process that begins with understanding the client's needs and objectives. This is followed by rigorous research into investment products, ensuring they meet regulatory requirements and are suitable for the identified client profile. Transparency and disclosure are paramount throughout the advisory process, with all potential risks and conflicts clearly communicated. Regular review of investments and ongoing client communication are also essential components of responsible financial advice. Question 7. The investigation demonstrates that a real estate agent in Western Australia is assisting a buyer with a property purchase. The buyer has indicated they will require a mortgage to complete the purchase and has asked the agent for help in filling out the mortgage application forms and recommendations for the best lender. What is the most appropriate course of action for the agent to take? Option A. Advise the buyer that they should engage a licensed mortgage broker or financial institution to assist them with their mortgage application and provide them with contact information for reputable brokers or lenders. Option B. Share the buyer's financial situation and desired loan amount with the seller to demonstrate the buyer's seriousness and ability to secure financing. Option C. Directly assist the buyer in completing the mortgage application forms and provide specific recommendations on which lender offers the most favorable terms based on the agent's experience. Option D. Inform the buyer that the mortgage approval is usually a straightforward process and that the agent can expedite it by liaising directly with the bank on their behalf. The correct answer is A. Advise the buyer that they should engage a licensed mortgage broker or financial institution to assist them with their mortgage application and provide them with contact information for reputable brokers or lenders. Explanation. This scenario presents a professional challenge because it requires a real estate agent in Western Australia to navigate the complexities of the mortgage application process while ensuring compliance with the relevant legislation and ethical obligations. The agent must balance the client's desire for a quick sale with the legal requirements and the lender's due diligence, all while maintaining transparency and acting in the best interests of their client. The critical element is understanding the agent's role and limitations in the mortgage application process. The best approach involves the agent facilitating the client's engagement with a qualified mortgage broker or lender. This approach is correct because it aligns with the principles of professional conduct and regulatory requirements in Western Australia. The agent's primary role is to facilitate the sale of the property, not to provide financial advice or directly manage the mortgage application. By referring the client to a licensed professional, the agent ensures that the client receives expert advice tailored to their financial situation, and that the mortgage application process is handled by individuals authorized and regulated to do so. This upholds the agent's duty of care and avoids potential conflicts of interest or breaches of legislation that prohibits unlicensed financial advice. An incorrect approach would be for the agent to directly assist the client in completing the mortgage application forms and advising them on which lender to choose. This is professionally unacceptable because it constitutes providing financial advice without the necessary licensing and authorization under Western Australian law, specifically the Corporations Act 2001, CTH, and potentially state-specific financial services regulations. Such actions could lead to significant legal and financial repercussions for both the agent and the client, and would breach the agent's duty to act within their scope of expertise and legal authority. Another incorrect approach would be for the agent to downplay the importance of the mortgage approval process to the buyer, suggesting it is a mere formality. This is ethically and regulatorily unsound. The mortgage approval is a critical condition of sale for most buyers, and its successful completion is essential for the transaction to proceed. Misrepresenting its significance can lead to a false sense of security for the buyer, potentially causing them to incur costs or make commitments based on an unrealistic expectation of securing finance. This breaches the agent's duty of utmost good faith and transparency towards their client. A further incorrect approach would be for the agent to share the buyer's sensitive financial information directly with the seller without the buyer's explicit consent. This is a serious breach of privacy and confidentiality, and potentially contravenes the Australian privacy principles under the Privacy Act 1988, CTH. While the seller has an interest in the sale proceeding, their need to know does not supersede the buyer's right to privacy regarding their financial details, which are integral to the mortgage application. Professionals should adopt a decision-making framework that prioritizes legal compliance, ethical conduct, and client best interests. This involves clearly defining their role and responsibilities, understanding the boundaries of their expertise, and knowing when and how to refer clients to other qualified professionals. In situations involving financial matters, such as mortgage applications, the framework dictates that agents should facilitate access to licensed financial advisors or mortgage brokers, rather than attempting to provide such services themselves. Transparency with all parties regarding the process and the agent's role is paramount. Question 8. A real estate agent in Western Australia is assisting a client who wishes to purchase an investment property quickly and is exploring financing options beyond traditional bank mortgages. The client has expressed interest in both hard money loans and seller financing as potential avenues. What is the most professional and ethically sound course of action for the agent in this situation? Option A. Facilitate a seller financing agreement by drafting a basic loan outline and encouraging the buyer and seller to sign it after the agent explains the key terms. Option B. Advise the client on the general characteristics and potential risks of hard money loans and seller financing, and strongly recommend they seek independent legal and financial advice to review any specific proposals before committing. Option C. Focus solely on presenting properties that are likely to be attractive to hard money lenders, without delving into the specifics of loan terms or advising on independent counsel. Option D. Recommend a specific hard money lender known for fast approvals and explain the benefits of their loan products to expedite the purchase. The correct answer is B. Advise the client on the general characteristics and potential risks of hard money loans and seller financing, and strongly recommend they seek independent legal and financial advice to review any specific proposals before committing. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in Western Australia due to the inherent risks and regulatory considerations associated with non-traditional financing methods like hard money loans and seller financing. The agent must navigate the potential for conflicts of interest, ensure full disclosure to all parties, and uphold their fiduciary duties while facilitating a transaction that might involve less conventional funding. The complexity arises from the need to balance the client's desire for a quick or flexible financing solution with the legal and ethical obligations to protect all parties from undue risk or misrepresentation. Correct approach analysis. The best professional practice involves thoroughly educating the client about the specific terms, risks, and implications of both hard money loans and seller financing, and then recommending they seek independent legal and financial advice before proceeding. This approach aligns with the agent's duty of care and disclosure under Western Australian real estate regulations. By facilitating access to independent professional advice, the agent ensures the client makes an informed decision, mitigating potential future disputes and upholding ethical standards. This proactive step protects both the client and the agent from potential liabilities arising from misunderstood loan terms or unforeseen financial consequences. Incorrect approaches analysis. Recommending a hard money lender without a comprehensive discussion of the high interest rates, short repayment terms, and potential for foreclosure is ethically problematic. It prioritizes a quick transaction over the client's long-term financial well-being and fails to meet the duty of care to fully inform the client of significant risks. Suggesting the seller finance option without advising the client to have the loan agreement independently reviewed by a legal professional is a failure to ensure the client understands the contractual obligations and potential recourse. This oversight could lead to disputes over loan terms, default, or enforcement, and breaches the agent's duty to act in the client's best interest by not ensuring adequate legal protection. Directly brokering a seller financing agreement between the buyer and seller without involving legal professionals for both parties, assuming the agent can adequately explain all legal nuances, is a significant ethical and regulatory breach. Real estate agents in Western Australia are not qualified to provide legal or financial advice, and attempting to do so constitutes practicing outside their scope and potentially misrepresenting complex legal agreements. Professional reasoning. Professionals should adopt a framework that prioritizes client education and the facilitation of independent expert advice. When dealing with non-traditional financing, the agent's role is to present options and their general characteristics, not to endorse or facilitate specific agreements without professional oversight. The process should involve 1. Understanding the client's needs and financial capacity. 2. Explaining the general nature and risks of available financing options, hard money, seller financing. 3. Strongly advising the client to consult with independent legal counsel and financial advisors to review any proposed agreements and assess their suitability. 4. Ensuring all disclosures required by the relevant Western Australian legislation are made. Question 9. The performance metrics show a significant increase in client inquiries regarding lower initial mortgage repayments. A client in Western Australia, Mr. Henderson, has approached you seeking a mortgage for his first home purchase and has expressed a strong preference for the lowest possible initial monthly payment. He believes he can manage slightly higher payments in the future if interest rates rise, but is primarily focused on affordability at the outset. Considering the available mortgage products in Western Australia, which approach best aligns with responsible lending obligations and ethical client advice. Option A. Suggest an interest-only mortgage for the entire loan term, focusing on the immediate benefit of minimal repayment and deferring discussion about principal repayment strategies until much later. Option B. Prioritize the option with the absolute lowest advertised initial repayment, regardless of the product type or its long-term implications for Mr. Henderson's financial stability. Option C. Advise Mr. Henderson to take an adjustable-rate mortgage, highlighting its lower initial interest rate and consequently lower initial payments, without extensively exploring his capacity to manage future rate increases. Option D. Recommend a fixed-rate mortgage for an initial period, explaining how this provides payment certainty and allows Mr. Henderson to establish his financial footing, while also discussing the potential for future adjustments or refinancing. The correct answer is D. Recommend a fixed-rate mortgage for an initial period, explaining how this provides payment certainty and allows Mr. Henderson to establish his financial footing, while also discussing the potential for future adjustments or refinancing. Explanation. Scenario analysis. This scenario is professionally challenging because it requires the mortgage broker to balance the client's immediate financial goals with their long-term capacity to manage debt. The client's desire for lower initial payments, while understandable, could expose them to significant future financial risk if not properly assessed. The broker must navigate the complexities of different mortgage products available in Western Australia, ensuring the advice provided is not only compliant with the National Consumer Credit Protection Act 2009, NCCP Act, and relevant Western Australian legislation, but also ethically sound and in the client's best interests. The risk lies in recommending a product that, while appealing initially, could lead to financial hardship for the client down the line, potentially resulting in breaches of responsible lending obligations. Correct approach analysis. The best professional practice involves thoroughly assessing the client's financial situation, risk tolerance, and future income stability before recommending a mortgage type. This includes understanding their capacity to handle potential increases in repayments, especially if considering an adjustable rate or interest-only mortgage. For clients seeking lower initial payments, and demonstrating a clear understanding of future repayment increases, recommending a fixed-rate mortgage that offers payment certainty for a defined period, while also discussing the potential benefits and drawbacks of other options, represents the most responsible approach. This aligns with the NCCP Act's responsible lending obligations, which mandate that lenders and brokers must take reasonable steps to ensure a credit product is not unsuitable for the consumer. A fixed-rate mortgage provides a predictable repayment schedule, mitigating the risk of payment shock that could arise from interest rate fluctuations, thus safeguarding the client's financial well-being. Incorrect approaches analysis. Recommending an adjustable-rate mortgage solely based on the client's initial desire for lower payments, without a comprehensive assessment of their ability to manage potential future increases in interest rates and repayments, would be a significant regulatory and ethical failure. This approach risks breaching responsible lending obligations by not adequately considering the client's capacity to repay the loan under various interest rate scenarios, suggesting an interest-only mortgage without a clear and documented understanding of the client's long-term repayment strategy, e.g., a robust plan for how the principal will be repaid at the end of the interest-only period, and their ability to service both interest and principal repayments in the future is also professionally unacceptable. This could lead to the client being unable to meet their obligations when the principal repayment phase begins, potentially resulting in default and contravening responsible lending principles, focusing exclusively on the lowest initial repayment option without exploring the long-term implications, and the client's overall financial health demonstrates a lack of due diligence. This prioritizes a short-term client desire over their long-term financial security, which is contrary to ethical lending practices and the spirit of consumer protection legislation in Western Australia. Professional reasoning. Professionals should adopt a client-centric approach, prioritizing their long-term financial well-being over immediate gratification. This involves a detailed fact-finding process to understand the client's financial circumstances, goals, risk appetite. When considering mortgage products, professionals must explain the features, benefits, risks, and costs of each option clearly and transparently, ensuring the client fully comprehends the implications of their choice. The decision-making process should be guided by the principles of responsible lending, ensuring that any recommended product is suitable for the client, and that they have the capacity to meet their repayment obligations throughout the life of the loan, in accordance with the NCCP Act. Question 10. Regulatory review indicates a buyer is purchasing a residential property in Perth, Western Australia, for $750,000. The buyer intends to occupy the property as their principal place of residence. Based on the Duties Act 2008, what is the estimated stamp duty payable, assuming the property qualifies for the principal place of residence concession? Option A, $18,945. Option B, $24,945. Option C, $28,945. Option D, $21,445. The correct answer is D, $21,445. Explanation. This scenario presents a common implementation challenge in Western Australian real estate financing, specifically concerning the calculation of stamp duty, also known as duties, on a residential property purchase. The challenge lies in accurately applying the relevant legislation, the Duties Act 2008 and its associated concessions, which can significantly impact the total cost of acquisition for the buyer. Professionals must navigate the nuances of the Act, including the principal place of residence concession, to provide accurate financial advice and avoid potential penalties for underpayment of duty. The best approach involves a precise calculation of the dutiable value and the application of the principal place of residence concession, as per Section 75 of the Duties Act 2008. This concession reduces the duty payable if the property is to be occupied by the purchaser as their principal place of residence within 12 months of the transaction, and for at least 12 months thereafter. The calculation requires determining the dutiable value of the property, and then applying the tiered duty rates, with the concession effectively lowering the applicable rate or providing a full exemption up to a certain value. This method ensures compliance with the Act and provides the most accurate financial outcome for the client. An incorrect approach would be to simply apply the standard duty rates without considering any potential concessions. This fails to meet the professional obligation to advise clients on all available legal benefits and could lead to the client overpaying duty. Another incorrect approach is to estimate the duty based on a general understanding of property values without performing the specific calculation according to the Duties Act 2008. This lacks the required diligence and accuracy, potentially misrepresenting the true cost of the transaction. Finally, assuming the concession applies without verifying the client's intention to occupy the property as their principal place of residence is also an unacceptable approach, as it relies on an unconfirmed future event and could lead to a reassessment and penalties if the conditions are not met. Professionals should adopt a systematic decision-making process. First, identify the relevant legislation, Duties Act 2008, Second, determine the dutiable value of the property. Third, research and apply all applicable concessions, verifying eligibility criteria. Fourth, perform the precise calculation using the prescribed rates and concessions. And fifth, clearly communicate the calculated duty liability and the basis for the calculation to the client, including any conditions attached to concessions. Question 11. Consider a scenario where two unrelated individuals in Western Australia are jointly purchasing a residential property. They have agreed to contribute equally to the purchase price and intend for their respective shares of the property to be inherited by their own families upon their deaths, rather than automatically passing to the surviving owner. What is the most appropriate method for documenting their ownership to ensure their intentions are legally protected? Option A. registering the property as a leasehold interest for the lifetime of both individuals. Option B, registering the property as a fee simple estate without specifying the nature of co-ownership. Option C, registering the property as a tenancy in common with each individual holding a distinct, undivided share. Option D, registering the property as a joint tenancy, relying on the presumption of survivorship. The correct answer is C, registering the property as a tenancy in common, with each individual holding a distinct, undivided share. Explanation: this scenario presents a professional challenge due to the potential for misunderstanding and dispute regarding property ownership rights, particularly when dealing with multiple parties and differing intentions. Navigating these complexities requires a thorough understanding of Western Australian property law and ethical obligations to ensure all parties are fully informed and their intentions are accurately reflected in legal documentation. Careful judgment is essential to prevent future legal entanglements and protect the interests of all stakeholders. The correct approach involves clearly identifying and documenting the specific type of ownership intended by the parties involved, ensuring it aligns with their understanding and the legal framework in Western Australia. This means accurately distinguishing between fee simple, outright ownership, leasehold, right to occupy for a period, joint tenancy ownership with right of survivorship, and tenancy in common ownership with distinct shares. For instance, if two individuals are purchasing a property together with the intention that their respective shares will pass to their heirs upon death, documenting this as a tenancy in common is crucial. This approach is correct because it adheres to the principles of the Transfer of Land Act 1893 WA and the common law governing property ownership. It ensures legal certainty, prevents unintended consequences like automatic survivorship in joint tenancy, and respects the parties' autonomy in determining how their property interests are held and devolved. An incorrect approach would be to assume a default ownership structure without explicit confirmation from the parties. For example, assuming joint tenancy when the parties intend to hold separate shares would lead to a failure to accurately reflect their wishes and could result in unintended inheritance outcomes, contravening the ethical duty to act in the best interests of the clients and potentially breaching statutory requirements for clear title registration. Another incorrect approach would be to use vague or ambiguous language in the ownership description, failing to specify whether it is fee simple or leasehold, or if it is a joint tenancy or tenancy in common. This ambiguity creates legal uncertainty and opens the door to disputes, failing to meet the professional standard of providing clear and accurate legal advice and documentation, as expected under the Property Law Act 1969. Furthermore, failing to explain the implications of each ownership type to the parties, particularly the right of survivorship in joint tenancy versus the distinct shares in tenancy in common, would be an ethical failure as it prevents informed consent. The professional reasoning process for similar situations should involve a structured approach. First, actively listen to and understand the client's stated intentions regarding property acquisition and future devolution of their interests. Second, educate the clients on the available ownership structures under Western Australian law, fee simple, leasehold, joint tenancy, tenancy in common, clearly explaining the rights, responsibilities, and implications of each, particularly concerning survivorship and inheritance. Third, confirm the client's chosen ownership structure in writing and ensure all legal documentation accurately reflects this confirmed intention. Finally, advise the clients to seek independent legal advice if there is any complexity or potential for conflict. Question 12. Upon reviewing your professional obligations as a licensed real estate salesperson in Western Australia, you discover that your annual Continuing Professional Development (CPD) hours are due for submission next month, and you are unsure if you have met the exact number of hours mandated by the Real Estate and Business Agents Act 2002. What is the most appropriate course of action to ensure you remain compliant and can continue practicing legally? Option A. Assume that your previous year's CPD activities were sufficient and wait until you receive a formal notification from the regulatory body regarding any deficiencies. Option B. Rely on informal discussions with colleagues to gauge whether your CPD hours are likely to be acceptable, as they often have a good understanding of the requirements. Option C. Immediately verify your current CPD activity records against the specific requirements outlined by the Department of Mines, Industry Regulation and Safety for Western Australian real estate salespersons, and if any shortfall exists, actively pursue and complete eligible CPD activities before the deadline. Option D. Focus on securing new listings and sales, as this is the primary driver of your business, and address the CPD requirements only if explicitly contacted about them. The correct answer is C. Immediately verify your current CPD activity records against the specific requirements outlined by the Department of Mines, Industry Regulation and Safety for Western Australian real estate salespersons, and if any shortfall exists, actively pursue and complete eligible CPD activities before the deadline. Explanation: this scenario is professionally challenging because it requires a real estate salesperson in Western Australia to balance client needs with strict regulatory compliance regarding licensing and continuing professional development. Failure to maintain an active and valid license can have severe consequences, including penalties and the inability to legally conduct real estate transactions. Careful judgment is required to ensure all obligations are met proactively. The correct approach involves proactively verifying the status of one's real estate salesperson's license and ensuring all continuing professional development (CPD) requirements are met in accordance with the Real Estate and Business Agents Act 2002 (WA) and its associated regulations. This includes understanding the specific CPD hours required annually, the types of activities that qualify for CPD, and the deadlines for completion. By actively managing these requirements, a salesperson ensures they are legally permitted to operate and uphold professional standards. This proactive stance prevents potential breaches of the Act and maintains the integrity of their professional practice. An incorrect approach involves assuming that a previously held license remains valid without verification, especially after a period of inactivity, or if there's uncertainty about renewal dates. This overlooks the statutory requirement to hold a current license to perform real estate agent or salesperson duties in Western Australia. It also fails to acknowledge that licenses may lapse or require specific renewal procedures, potentially leading to an unlicensed practice, which is a serious offense under the Act. Another incorrect approach is to disregard or underestimate the importance of continuing professional development. Real Estate and Business Agents Act 2002 (WA) mandates specific CPD obligations for licensed individuals. Failing to meet these requirements, even if the license itself is technically current, can lead to disciplinary action, including fines or suspension, as it demonstrates a lack of commitment to maintaining up-to-date knowledge and skills relevant to the profession. A further incorrect approach is to rely solely on informal advice or assumptions about licensing and CPD requirements without consulting official sources or the relevant regulatory body in Western Australia. This can lead to misinterpretations of the law and noncompliance. Professionals should always refer to the official guidelines provided by the Department of Mines, Industry Regulation and Safety, or the relevant licensing authority to ensure accurate understanding and adherence to all legal obligations. The professional decision-making framework for such situations should involve a commitment to continuous learning and compliance. This includes 1. Regularly reviewing personal licensing status and renewal dates. 2. Proactively identifying and tracking required CPD activities well in advance of deadlines. 3. Consulting official regulatory resources for clarification on any requirements. 4. Maintaining meticulous records of CPD completion. 5. Seeking professional advice when in doubt. This systematic approach ensures ongoing compliance and upholds professional integrity. Question 13. When evaluating a situation in Western Australia where a real estate agent's close friend expresses interest in purchasing a property the agent is currently listing for a seller client, what is the most appropriate course of action for the agent to take? Option A. Advise the friend to engage a different real estate agent to handle their offer to avoid any appearance of impropriety. Option B. Downplay the nature of the personal relationship to the seller client and continue the sales process as usual. Option C. Proceed with showing the property to the friend and discussing potential terms, assuming the personal relationship is not a significant factor in the transaction. Option D. Immediately disclose the personal relationship to the seller client and seek their informed consent before engaging further with the friend regarding the property. The correct answer is D. Immediately disclose the personal relationship to the seller client and seek their informed consent before engaging further with the friend regarding the property. Explanation: This scenario presents a professional challenge because it requires a real estate agent in Western Australia to navigate a situation where a potential buyer, who is also a friend, expresses interest in a property listed by the agent's agency. The core conflict lies in balancing the agent's fiduciary duties to their seller client with the personal relationship and potential for perceived or actual conflict of interest. Careful judgment is required to ensure transparency, fairness, and adherence to regulatory obligations under the Real Estate and Business Agents Act 2002, WA, and its associated regulations. The best professional approach involves immediately disclosing the personal relationship to the seller client and obtaining their informed consent before proceeding with any discussions or negotiations with the friend. This approach upholds the agent's primary duty to act in the best interests of the seller. By proactively informing the seller about the potential conflict, the agent allows the seller to make an informed decision about whether they are comfortable with the agent continuing to represent them in this specific transaction. This transparency is a cornerstone of ethical real estate practice and aligns with the principles of good faith and avoiding undisclosed conflicts of interest mandated by Western Australian legislation. An incorrect approach would be to proceed with showing the property to the friend and discussing terms, without informing the seller of the personal relationship. This failure constitutes a breach of the agent's duty of disclosure and loyalty to the seller, potentially leading to a conflict of interest that is not managed transparently. It undermines the seller's trust and could be seen as prioritizing the agent's personal relationship over the seller's best interests, which is a violation of regulatory requirements. Another incorrect approach would be to advise the friend to make an offer through another agent to avoid any perceived conflict, without first discussing the situation with the seller client. While this might seem like an attempt to sidestep the issue, it bypasses the seller's right to be informed and to decide how they wish to proceed with their property sale. The agent has a duty to their current client, the seller, and should not unilaterally decide to circumvent the sales process without consultation. Finally, an incorrect approach would be to downplay the personal relationship to the seller and proceed as if it were a standard buyer interaction. This lack of full and frank disclosure is a serious ethical and regulatory failing. It prevents the seller from understanding the full context of the transaction and making an informed decision, thereby compromising the agent's integrity and potentially exposing them to disciplinary action. Professionals should adopt a decision-making framework that prioritizes transparency, client interests, and regulatory compliance. When a potential conflict of interest arises, the first step is always to identify it. Then, the professional must assess the nature and severity of the conflict. The next crucial step is to communicate openly and honestly with all relevant parties, particularly the client, to explain the situation and explore potential resolutions. Obtaining informed consent from the client is paramount before proceeding. If a conflict cannot be adequately managed or resolved to the satisfaction of all parties and in compliance with regulations, the professional should consider withdrawing from the transaction. Question 14. The analysis reveals that a proposed major infrastructure project in Perth, Western Australia, is likely to significantly alter the local economic landscape. A real estate agent is advising a client who owns a residential property in the affected area. Which of the following actions best demonstrates professional and regulatory compliance in advising the client on potential market value impacts? Option A. Recommending an immediate price increase for the property based on the general positive sentiment surrounding large infrastructure developments in Western Australia, without detailed analysis of the specific project's localized effects. Option B. Researching publicly available reports on the project's scope, consulting local planning documents, and presenting a balanced assessment of potential positive and negative impacts on property values, supported by objective data and expert opinions relevant to the Western Australian market. Option C. Relying on informal discussions with other real estate agents in the area to gauge the likely market reaction, and advising the client based on these anecdotal observations. Option D. Focusing solely on the potential for increased property values due to improved accessibility, while omitting any discussion of potential negative impacts such as increased traffic or construction disruption in the immediate vicinity. The correct answer is B. Researching publicly available reports on the project's scope, consulting local planning documents, and presenting a balanced assessment of potential positive and negative impacts on property values, supported by objective data and expert opinions relevant to the Western Australian market. Explanation. The analysis reveals a scenario where a real estate agent in Western Australia must advise a client on the potential impact of a proposed major infrastructure project on their property's market value. This situation is professionally challenging because it requires balancing the client's financial interests with the need for accurate, unbiased information and avoiding any misrepresentation that could violate the Real Estate and Business Agents Act 2002 (WA) and its associated regulations. The agent must navigate the speculative nature of future market impacts while adhering to ethical obligations of disclosure and competence. The best approach involves conducting thorough research into the specific details of the proposed infrastructure project, its projected timeline, and its likely economic and social impacts on the immediate and surrounding areas of the property. This research should include consulting publicly available government reports, local council planning documents, and reputable economic forecasts relevant to Western Australia. The agent should then present a balanced assessment to the client, outlining both potential positive and negative impacts on property values, supported by objective data and expert opinions where available. This approach aligns with the agent's duty to act honestly and professionally, providing advice that is based on reasonable grounds and is not misleading, as mandated by the Code of Conduct for licensed agents under the Act. It demonstrates competence and diligence in understanding the local market dynamics and relevant economic factors. An incorrect approach would be to make definitive predictions about significant price increases solely based on the announcement of the project, without substantiating this with detailed analysis. This could lead to misrepresentation and breach the agent's duty to provide accurate information. Another incorrect approach is to downplay or ignore potential negative impacts, such as increased traffic noise or disruption during construction, which could also mislead the client about the full spectrum of market influences. Furthermore, relying on anecdotal evidence or speculation from other market participants without independent verification would be unprofessional and could violate the agent's obligation to act with due care and skill. Professionals should adopt a decision-making process that prioritizes objective data and thorough due diligence. This involves identifying all relevant factors, both positive and negative, that could influence property values. The agent must then critically evaluate the reliability and potential impact of each factor, drawing on credible sources and their professional expertise. Transparency with the client is paramount. All findings, including uncertainties and potential risks, should be clearly communicated, allowing the client to make informed decisions based on a comprehensive understanding of the market landscape. Question 15. Benchmark analysis indicates that a licensed real estate agent in Western Australia is preparing a valuation for a standard residential property. Considering the typical market dynamics and regulatory expectations in WA, which valuation method would best align with professional obligations to provide an accurate and defensible market value? Option A. Comparative market analysis. By examining recent sales of similar properties in the immediate vicinity and adjusting for differences. Option B. A hybrid approach combining elements of all three methods without specific justification for each component. Option C. Cost approach, by estimating the replacement cost of the property and deducting depreciation. Option D. Income approach, by projecting potential rental income and applying a capitalization rate. Correct answer is A. Comparative market analysis, by examining recent sales of similar properties in the immediate vicinity and adjusting for differences. Explanation. Scenario analysis. This scenario presents a professional challenge for a licensed real estate agent in Western Australia, WA, tasked with providing a valuation for a property. The challenge lies in selecting the most appropriate valuation method given the unique characteristics of the property and the purpose of the valuation. A superficial or incorrect approach can lead to misrepresentation, financial detriment for the client, and potential breaches of professional conduct and regulatory obligations under the Real Estate and Business Agents Act 2002 (WA) and its associated regulations. Careful judgment is required to ensure the valuation is accurate, defensible, and ethically sound. Correct approach analysis. The most appropriate approach in this scenario is the comparative market analysis. This method involves analyzing recent sales of similar properties in the same or a very similar location, adjusting for differences in features, condition, and amenities. This approach is correct because it directly reflects current market conditions and buyer behavior in Western Australia. The Real Estate and Business Agents Act 2002, WA, and the Code of Conduct for Licensed Agents implicitly require agents to act honestly and competently, which includes providing valuations that are grounded in observable market data. Relying on recent, comparable sales provides the most objective and relevant indication of a property's market value in the WA context, particularly for residential properties where direct comparison is most feasible. Incorrect approaches analysis. Using the income approach would be professionally unacceptable in this scenario. While valuable for investment properties, it relies on projecting future rental income and applying a capitalization rate. This method is less reliable for a standard residential property, where the primary purpose of valuation is not income generation, and future rental income can be speculative. It fails to directly reflect the current market demand and sale prices of comparable residential properties in WA, potentially leading to an inaccurate valuation and a breach of the duty to provide competent advice. Employing the cost approach would also be professionally unacceptable. This method estimates the cost to replace or reconstruct the property, less depreciation. It is generally best suited for unique properties, new construction, or properties where comparable sales data is scarce. For a typical residential property in Western Australia, this approach is often less relevant as it does not directly account for market demand, buyer preferences, or the specific economic factors influencing sale prices in the local area. Over-reliance on construction costs can lead to a valuation that is significantly out of step with what a buyer would realistically pay in the current WA market, thus failing to meet the standard of competent and honest practice. Professional reasoning. Professionals in Western Australia must adopt a systematic approach to property valuation. This involves first understanding the purpose of the valuation and the specific characteristics of the property. Then, they should consider the most relevant valuation methods for that property type and market. The comparative market analysis is generally the primary method for residential properties in WA due to its direct reflection of market activity. If this method is not feasible due to a lack of comparable sales, then other methods may be considered, but their limitations must be clearly understood and communicated. Ethical practice dictates that the chosen method should provide the most accurate and defensible estimate of market value, aligned with the principles of competence and honesty enshrined in WA legislation. Question 16. Implementation of a robust maintenance and repairs management process for a rental property in Western Australia requires a property manager to respond effectively to tenant-reported issues. If a tenant reports a significant water leak from the ceiling in their Perth apartment, what is the most appropriate initial course of action for the property manager? Option A. Wait for the owner to provide explicit approval for any repair work before contacting any tradespeople, even if the leak is substantial. Option B. Immediately assess the urgency of the leak, arrange for a qualified tradesperson to attend to the repair as soon as practicable, and inform the owner of the situation and the action taken. Option C. Inform the tenant that they are responsible for arranging and paying for the repair themselves, and to seek reimbursement from the owner later. Option D. Advise the tenant to wait until the next scheduled property inspection to have the issue assessed by the property manager. The correct answer is B. Immediately assess the urgency of the leak, arrange for a qualified tradesperson to attend to the repair as soon as practicable, and inform the owner of the situation and the action taken. Explanation. The scenario of a tenant reporting a significant maintenance issue in a Western Australian rental property presents a professionally challenging situation for a property manager. Challenge lies in balancing the tenant's right to a safe and habitable living environment with the property owner's financial obligations and the property manager's duty of care. Prompt and appropriate action is crucial to avoid potential breaches of the Residential Tenancies Act 1987, WA, and to maintain a positive landlord-tenant relationship. Careful judgment is required to assess the urgency of the repair, communicate effectively with all parties, and ensure compliance with legal timelines. The correct approach involves immediately assessing the reported issue for urgency, and if deemed urgent, arranging for the necessary repairs to be carried out by a qualified tradesperson as soon as practicable, while simultaneously notifying the owner of the situation and the proposed course of action. This aligns with the property manager's obligations under the Residential Tenancies Act 1987, WA, specifically regarding the landlord's duty to ensure the premises are kept in a good state of repair and are fit for habitation. Prompt action demonstrates adherence to the Act's provisions for urgent repairs, which typically require attention within 48 hours. It also reflects ethical practice by prioritizing the tenant's well-being and the property's integrity. An incorrect approach would be to delay action by waiting for the owner's explicit approval for any repair, regardless of the reported issue's urgency. This fails to acknowledge the landlord's statutory obligation to maintain the property and the tenant's right to a habitable dwelling. Such a delay could constitute a breach of the Residential Tenancies Act 1987, WA, if the repair is classified as urgent, potentially leading to penalties or disputes. Another incorrect approach would be to inform the tenant that they are responsible for arranging and paying for the repair themselves, even if the issue is clearly the landlord's responsibility. This directly contravenes the landlord's obligations under the Residential Tenancies Act 1987, WA, and shifts a burden that legally rests with the owner. It also demonstrates a lack of understanding of the property manager's role in facilitating necessary maintenance. A further incorrect approach would be to dismiss the tenant's report as minor without proper assessment, and to advise them to simply wait it out until the next scheduled inspection. This neglects the potential for minor issues to escalate into more significant and costly problems, and more importantly, it fails to address potential health and safety concerns for the tenant, which is a fundamental responsibility under Western Australian tenancy law. Professionals should adopt a decision-making framework that prioritizes tenant safety and legal compliance. This involves 1. Actively listening to and documenting tenant repair requests. 2. Assessing the urgency and nature of the reported issue against the landlord's obligations under the Residential Tenancies Act 1987, WA. 3. Communicating promptly and clearly with both the tenant and the owner. 4. Engaging qualified tradespeople for urgent repairs without undue delay, while keeping the owner informed. And 5. Maintaining thorough records of all communications and actions taken. Question 17. To address the challenge of securing a property listing in Western Australia, an agent is considering different commission structures. Which of the following approaches best aligns with professional conduct and the regulatory framework governing real estate agents in Western Australia? Option A. Offering a negotiable commission rate without providing any specific range or parameters, leaving the final figure entirely open-ended until the property is sold. Option B. Agreeing to a verbal understanding of a commission rebate to the seller upon successful sale, which will not be formally documented in the listing agreement. Option C. Suggesting a commission structure heavily weighted towards achieving a sale price significantly above market value, implying this will motivate the agent to secure an exceptional deal. Option D. Proposing a clearly defined commission percentage or fixed fee, detailed in a written listing agreement that explicitly outlines all services included and is fully explained to the seller. The correct answer is D. Proposing a clearly defined commission percentage or fixed fee, detailed in a written listing agreement that explicitly outlines all services included and is fully explained to the seller. Explanation. To address the challenge of ensuring fair and transparent commission structures in Western Australian real estate, a real estate agent must navigate the complexities of client agreements and regulatory expectations. The scenario is professionally challenging because the agent is attempting to secure a listing by offering a commission structure that, while potentially attractive to the seller, could lead to conflicts of interest or misrepresentation if not clearly communicated and legally sound. Careful judgment is required to balance the agent's desire to secure business with their fiduciary duty to the client and adherence to Western Australian, WA, real estate legislation. The best professional approach involves presenting a commission structure that is clearly defined, legally compliant with the Real Estate and Business Agents Act 2002 WA and its associated regulations, and fully understood by the seller. This means detailing the exact percentage or fixed fee, outlining any potential tiered structures or bonuses, and specifying what services are included in that fee. Crucially, this structure must be documented in a written agreement, such as a listing agreement, signed by both parties. This approach is correct because it prioritizes transparency, informed consent, and compliance with WA's regulatory framework, which mandates clear contractual terms for agency agreements. It upholds the agent's ethical obligation to act in the client's best interest, by ensuring the client fully understands the financial implications of the agency relationship. An incorrect approach would be to offer a commission structure that is vague or misleading, such as suggesting a negotiable commission, without providing any parameters or a clear path to negotiation. This is professionally unacceptable because it fails to provide the seller with the necessary information to make an informed decision about the agent's remuneration, creates ambiguity and potential for disputes, contravening the spirit of transparency expected under WA real estate law. Another incorrect approach is to propose a commission structure that is contingent on achieving an unrealistically high sale price, with the implication that the agent will work harder to achieve this target. While performance-based incentives can be legitimate, if the target is set in a way that suggests the agent can artificially inflate the price, or that their effort is directly tied to an arbitrary figure rather than market value, it can be seen as misleading. This could breach ethical duties by potentially prioritizing the agent's higher commission over the seller's best interests in achieving a realistic and timely sale. Finally, proposing a commission structure that includes undisclosed rebates or incentives to the seller outside of the written agreement is also professionally unacceptable. Such practices can be considered inducements that are not transparently disclosed to all parties involved or to the regulator. This lack of transparency undermines the integrity of the transaction and may contravene specific provisions within WA's real estate legislation regarding disclosure and fair dealing. Professionals should adopt a decision-making process that begins with understanding the client's needs and expectations. They must then consider the relevant WA legislation and ethical guidelines governing commission structures. All proposed fee arrangements should be clearly articulated, documented in writing, and fully explained to the client, ensuring informed consent. Any deviation from standard, transparent practices should be scrutinized for potential conflicts of interest or regulatory breaches. Question 18. Examination of the data shows a property manager in Western Australia is tasked with selecting a new tenant for a residential property. The manager has received applications from several individuals, one of whom is a single parent with 2 young children. The manager is concerned that this applicant might lead to increased wear and tear on the property and potential noise disturbances, and therefore is considering rejecting their application in favor of another applicant who appears to be a quiet, single professional. What is the most appropriate course of action for the property manager to take in accordance with Western Australian fair housing laws and anti-discrimination regulations? Option A. Accept the applicant who appears to be a quiet, single professional without a formal assessment of the single parent's application to avoid potential future issues. Option B. Inform the applicant that properties managed by the agency tend to attract a quieter demographic and suggest they might find a more suitable property elsewhere. Option C. Evaluate the applicant based solely on objective criteria such as rental history, financial capacity, and references, ensuring no consideration is given to their family status or the presence of children. Option D. Reject the application from the single parent due to concerns about potential increased wear and tear and noise, prioritizing the applicant who appears to be a quiet, single professional. Correct answer is C. Evaluate the applicant based solely on objective criteria such as rental history, financial capacity, and references, ensuring no consideration is given to their family status or the presence of children. Explanation. This scenario presents a professional challenge because it requires navigating the delicate balance between legitimate business interests and the strict anti-discrimination provisions of Western Australian WA fair housing laws. A property manager must act impartially and avoid any actions that could be perceived as discriminatory, even if the underlying motivation appears to be a desire to maintain a certain character for the property or complex. The risk of contravening the Equal Opportunity Act 1984, WA, is significant if subjective criteria are applied in a way that disadvantages protected groups. The best approach involves a thorough understanding and strict adherence to the Equal Opportunity Act 1984. This means evaluating all prospective tenants based on objective, non-discriminatory criteria directly related to their ability to fulfill the tenancy agreement, such as financial stability, rental history, and references. The property manager should have a clear, documented, and consistently applied selection policy that does not include or imply any consideration of personal characteristics protected under the Act, such as race, religion, gender, or family status. This approach ensures compliance with WA law by focusing solely on the applicant's suitability as a tenant, thereby preventing any form of unlawful discrimination. An incorrect approach would be to reject an applicant based on a subjective assessment of their lifestyle or perceived fit with existing residents, especially if this assessment is influenced by stereotypes or assumptions about their background. For example, assuming a family with young children will be too noisy or disruptive, without any objective evidence from their rental history, could constitute indirect discrimination based on family status, which is prohibited under the Equal Opportunity Act 1984, WA. Similarly, rejecting an applicant because their cultural background might lead to different living habits that the property manager finds undesirable, without any objective basis related to property damage or disturbance, would be a direct contravention of the Act. Another flawed approach is to prioritize applicants who are similar to current tenants, as this can perpetuate a homogeneous community and inadvertently exclude individuals from diverse backgrounds, leading to indirect discrimination. Professionals should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves establishing clear, objective selection criteria for all prospective tenants, ensuring these criteria are applied consistently to every applicant, and maintaining thorough, factual documentation of the assessment process. Regular training on anti-discrimination laws and fair housing practices in WA is crucial. When in doubt, seeking legal advice or consulting with relevant industry bodies is a prudent step to ensure all decisions are defensible and compliant with the Equal Opportunity Act 1984, WA. Question 19. Research into lease agreements in Western Australia reveals that different types of leases carry distinct legal obligations and tenant protections. A client is seeking advice on whether to enter into a new residential lease agreement. What is the most appropriate way for a real estate agent to explain the implications of a fixed-term lease versus a periodic lease under the Residential Tenancies Act 1987 WA? Option A. Recommend a standard fixed-term agreement without further inquiry, assuming it is the most common and therefore the best option for all clients. Option B. State that a periodic lease offers the same security of tenure as a fixed-term lease, as neither can be terminated without a valid reason. Option C. Advise the client that a fixed-term lease will automatically convert to a month-to-month arrangement after the initial term, and that this is generally simpler for both parties. Option D. Clearly explain that a fixed-term lease has a set end date and specific conditions for early termination, while a periodic lease continues indefinitely until proper notice is given by either party, detailing the differing notice periods and rent review possibilities under WA law. The correct answer is D. Clearly explain that a fixed-term lease has a set end date and specific conditions for early termination, while a periodic lease continues indefinitely until proper notice is given by either party, detailing the differing notice periods and rent review possibilities under WA law. Explanation. Scenario analysis. This scenario presents a professional challenge for a real estate agent in Western Australia due to the potential for misrepresentation and breach of duty of care when advising a client on lease agreements. The agent must navigate the nuances of different lease types and their implications for both landlords and tenants, ensuring compliance with the Residential Tenancies Act 1987, WA, and general principles of fair dealing. Failure to accurately advise can lead to disputes, financial loss, and damage to the agent's reputation and licensing. Correct approach analysis. The best professional practice involves clearly distinguishing between a fixed-term lease and a periodic lease, explaining the key differences in termination clauses, notice periods, and the stability of rent and terms. This approach directly addresses the client's need for clarity by outlining the specific legal implications of each type under Western Australian law, particularly referencing the Residential Tenancies Act 1987, WA, regarding notice periods and termination rights for both parties. It prioritizes informed consent and empowers the client to make a decision based on accurate legal understanding. Incorrect approaches analysis. Advising the client that a fixed-term lease automatically converts to a month-to-month arrangement without explicitly detailing the legal framework governing this transition under WA law is misleading. This fails to acknowledge that while this can occur, the specific notice requirements and conditions for termination under the Residential Tenancies Act 1987, WA, must be understood. Suggesting that a periodic lease offers the same security of tenure as a fixed-term lease is factually incorrect and breaches the duty to provide accurate information. Periodic leases, by their nature, offer less certainty regarding rent increases and termination. Recommending a lease agreement without understanding the client's specific needs, and then assuming a standard fixed-term agreement is appropriate, overlooks the agent's obligation to provide tailored advice and could lead to an unsuitable arrangement for the client. Professional reasoning. Professionals should adopt a client-centric approach, beginning with a thorough understanding of the client's objectives and risk tolerance. This involves clearly defining the available options, explaining their legal ramifications under the relevant Western Australian legislation, primarily the Residential Tenancies Act 1987 (WA), and empowering the client to make an informed decision. Transparency about the differences between lease types, including termination rights and notice periods, is paramount. Question 20. Which approach would be most appropriate for a real estate agent in Western Australia when advising a seller on their potential net proceeds from a property sale, given the following information? Sale price, $750,000, agent's commission, 5% of sale price, stamp duty transfer duty on buyer, $22,500 paid by buyer but impacts negotiation. Legal fees seller, $2,000, council rates pro rata adjustment, $800, water rates pro rata adjustment, $400, mortgage discharge fee, $500. Option A. Inform the seller that calculating net proceeds is their responsibility and the agent can only provide the gross sale price. Option B. Present only the gross sale price of $750,000 to the seller, stating that all other costs are separate and will be deducted later. Option C. Calculate the net proceeds by subtracting the agent's commission and legal fees, but estimate the pro rata rates and mortgage discharge fee at a lower, round figure to present a more favorable net amount. Option D. Calculate the estimated net proceeds by subtracting all known seller expenses, commission, legal fees, pro rata rates, mortgage discharge fee, from the sale price, and present this figure along with a breakdown of all deductions. The correct answer is D. Calculate the estimated net proceeds by subtracting all known seller expenses, commission, legal fees, pro rata rates, mortgage discharge fee, from the sale price, and present this figure along with a breakdown of all deductions. Explanation. This scenario presents a professional challenge due to the potential conflict between a client's immediate financial desires and the legal requirements for a valid contract, particularly concerning the disclosure of material facts in Western Australian real estate transactions. The agent must navigate these competing interests ethically and legally. The correct approach involves accurately calculating the net proceeds based on the agreed-upon sale price, and then presenting this figure to the client, along with a clear explanation of all associated costs and deductions. This aligns with the agent's fiduciary duty to act in the client's best interest, which includes providing transparent and accurate financial information. Under Western Australian property law and the Real Estate and Business Agents Act 2002, agents have a duty of care and skill, and must not mislead or deceive clients. Presenting a net figure that accounts for all known expenses ensures the client makes an informed decision based on realistic expectations. An incorrect approach would be to simply provide the gross sale price without detailing the deductions. This fails to meet the duty of transparency and can lead to the client having unrealistic expectations about their financial outcome, potentially causing disputes and breaching the agent's ethical obligations. Another incorrect approach would be to estimate the net proceeds by rounding down the expenses to make the net figure appear more attractive. This constitutes misleading conduct and a breach of the agent's duty to provide accurate information. Such an action could have legal ramifications and damage the client's trust. A further incorrect approach would be to refuse to provide any net proceeds calculation, stating it is the client's responsibility to figure it out. This shirks the agent's professional responsibility to assist the client in understanding the financial implications of the sale, which is a core aspect of providing competent agency services. Professionals should approach such situations by first understanding all contractual obligations and associated costs. They should then perform precise calculations and present these clearly to the client, explaining each component. If there are uncertainties in costs, these should be clearly communicated as estimates with appropriate caveats. The ultimate goal is to empower the client with accurate information for informed decision-making.